But on that note, I would like to thank Bernard and speakers.
Michael, I had a few benefactors lately. Now, look, it's an honour to follow so many distinguished Derek Fielding Memorial addressees, including Michael Kirby, who, of course, and one or two others who I know. It's an honour to be here, and of course I would find my own way here to speak to a Council for Civil Liberties, because you're such an important crowd and such an important element in our democracy. It's quite appropriate that the first speech I give publicly for some considerable time, and the first speech I give since the Federal Attorney General Mark Dreyfus decided not to proceed with the prosecution action against me, appropriate that it be in Queensland before the Council for Civil Liberties. So I had quite a number of invites, and I thought of the sterling work that your council and your prior presidents, particularly Terry Gorman and others, have done, and I thought it would be appropriate to come up here, speak first about the circumstances, necessary notoriety in my life. Put it plainly, I'm still subject to orders made, as Grant Donaldson, the National Security Monitor, said in his findings on the Witness J matter a couple of weeks ago. I'm still subject in perpetuity to secrecy orders. So while the whole world can say some things happened once in Dili, I may not, without committing an offence. So you could bear that in mind if you ask me some questions. Now, the subject I chose I thought would be reasonably safe, the challenge of representing the interests of members of the intelligence community. Because that's where I found myself in relation to the Witness K matter. Witness K was an approved client, that is, a member of the Australian Secret Intelligence Service who sought advice. To do that, he needed permission to be a private lawyer. That private lawyer had to be someone the Secret Service and Inspector General of Intelligence Security approved of. And dare I say, because it's secret, that Witness K, not the first such client of mine, Australian intelligence community. In fact, for some reasons or other I won't go into, I've had a long association with that community. And indeed, when I was, as Michael put it, I'd quite forgotten it, first secretary in the Australian Embassy in Paris, I had under my supervision the ASIO office, that part of Europe. So the extraordinary conjunction of events with Witness K was that I had been an advisor to the East Timorese resistance for many years, and I was still working closely with the East Timorese leadership, Chinana Guzmao, Ramos Horta, at all relevant times. And in that role as the assigned legal advisor to the National Timorese resistance, I was living, working, travelling, sleeping, not in the biblical sense, of course, with Chinana Guzmao and other leaders as Anne there over their nose. And my involvement with East Timor goes back to when I was in my early 20s, receiving some special training. And one of those trainings was the former Z Force Commando, who told me as a young man and trained me about the East Timorese, assisting the Portuguese Timorese, as they're then known, assisting our soldiers who were caught behind the lines when the Japanese overran Timor. And they were extraordinary stories. The picture us being trained 20 years after the war by someone who'd been fighting behind the lines, a very bestial, slowly, that way or that on. Sorts of things like that. So association with sorts of things like that back a long way. But to tell you, I worked very hard in the years to defence and imagine my reaction. But imagine, just think of it. Imagine after years and years of assisting the Timorese resistance and working with the leader of the resistance, Chinana Guzmao, and developing what I could in terms of trust, in terms of necessary defence, intelligence liaison, to have witness K tell me something so marked with treachery would still fail me. So marked with treachery, so immoral, so unethical, but worse still, so counter to all of our national interests. This was putting 30 pieces of silver in money, corporate money, ahead of our interests, ensuring that we developed Timorese and we outplayed those others who were interested, particularly China. And so at that time also, I was assisting the St James Ethics Centre in Sydney with work we were doing in our region. We were taking young Australian leaders from industry, the Defence Forces, from police, government departments, here in Queensland, young people, under Chatham House rule. We were taking them to meet young leaders in Hanoi, Jakarta, Cambodia, and other places. We would have conferences with those young leaders, some of whom now I'm talking to, now senior leaders in communist countries and other countries. Simon Longstaff, a philosopher, leading Fairfax family, John Fairfax in particular, was funding it, being done quietly. At the same time, there was a group from Finland trying to deal with the problems in Aceh, as you know, tragically was resolved by an army wave in the air. And so during that period of us trying to impose leadership morality and ethics neighbours, convince them that we need to have exemplary leadership in our nations. While I was doing that, I was finding out from something that was the very antithesis of what James Ethics was doing and what I was doing personally in my spare time, my trial work. So it was a very traumatic year or two while I investigated what I'd been told by witnesses. Now, my concern tonight is how would a future witness K, how will LM be treated? Now, situation got worse, got potentially better because government is gone. But I need to sound a warning about half measures and whether we'll have a return to orthodoxy. Come to that. I've got to say how grateful I am to Mark Dreyfus and Penny Wong, because I both know I had breakfast with Joseph sort of the other morning, and I know that Penny Wong had a good hand in this as well, for reasons of state, not necessarily to be kind to me, but I accept the reality of the situation. Now, I've often wondered what I was doing in the months in 2000 when the National Security Information, Criminal and Civil Proceedings Act 2004 was debated in the federal parliament. It's an extraordinary document, contents of which few of us are familiar with. I certainly wasn't. I don't know how it got through. I think after 9/11, the Labor Party was pretty well wedged, subsequently read the Hansard, and we were trusting, never entered our heads that law being introduced to deal with terrorism actually went against us, first and foremost, what the NSI Act has. The only person under that legislation who have been treated to the full measure of it. Been a number of terrorist trials, and really being the lead judge, or was, he's retired now, really did the Lodi trial and the others where there was some test of these laws, but they were not essentially commercial. Very important, that identity of about terrorism, identity of involved encounters, etc. are protected. It's very important, necessary. But provisions in that act allow judge-only evidence, allow evidence to be led against an accused. Accused cannot see, that the accused lawyers cannot see, and that the prosecution allegedly can't see, but that the judge can see, occurred in my case. Had this sinister event where the Attorney General, Michaela Cash's carried a cachet, back to medieval, secret cachet to the judge to read. None of the rest of us. Australia, late last year. Not including the prosecution allegedly. I'm going to come to that. So, and that was called judge-alone evidence. And there were numerous occasions during the 60-odd appearances, well, we fought them, numerous occasions when we were all asked. Now, during that 4 years, The law firm Gilbert and Tobin in Sydney represented me, together with equally stellar troupe of barristers. I'd already ensured that Brett was briefed to get witness K's passport back, which wasn't agreed with the court. Should, and a great team of lawyers and barristers, and Stephen Combe over here knows that a great portion of the bar in Australia has staunchly supported me. Our councils have, all council, etc. I must say that lifted my spirits at times to get that support so important. Now, only a proper exposure of what happened to Ray and myself will convince the Albanese government not to be content with harm. The federal attorney has asked the National Security Monitor, Donaldson FD, the whole of that act, NSI Act as it's hopeful that that review will show some things. It's already done a mini review of Witness J matter. You know who Witness J was. Witness J was a member of the intelligence community, allegedly stepped out of line. He was tried and sentenced. Grant Donaldson has revealed that warrants were issued by the Chief Magistrate in Canberra, apparently in chambers, apparently with no record kept of what was presented to us for the warrants. He's looking at that issue. And I don't want to tell you that as the former Attorney General, the former person who appoints magistrates and judges, how gobsmacked I found out early this year, 55 warrants issued over time affecting health, exception warrants that could only include lengthy period dealings with civil colleagues, government, any others. Thought that my own magistrates been involved in issuing those warrants means that calling tonight, Grant Donaldson carefully in going on. As you know, K was approved to take private legal measures, and I did, and they were taken. It was appalling for us to find out early this year, finally, after 4 years of fighting to know what had gone on, that all of drafting, settling of pleadings, memorials, the statements of claim at The Hague, they were all being accessed in real time by Australian. So could you imagine that the memorials we were preparing and drafting, Cambridge, colleagues, and lawyers, living at Trinity College, all those years of work were being government. The impropriety of it is staggering, extraordinary. Now, when brief was seized way back in December 2013, my office immediately applied for provisional measures from the International Court. Provisional measures are the sort of measures that are applied for by the Security Council to stop the Indian firing. Very unusual for a provisional measures application against Australia to have my brief and all the documents seized from my chambers returned. The International Court ordered the documents to be sealed, and the then attorney, George Brandis, undertook their sealing. But the court was not satisfied just with that undertaking and gave an order that there be no interference at all. I'll read it to you. Australia shall not interfere in any way in communications between Timor-Leste and its legal advisors in connection with the pending arbitration, with any future bilateral negotiations concerning maritime delimitation, or any other related procedure between the two states, including the present case before the. So early this year, we found out that they had gained, quote, insidiously, the words, warrant access to my personal standalone computer. Must have been when I was asleep, because I slept with it most of the time. But they had access to all of our memorials and drafting. My team was in UK, and that's the respect you can give to Australia's undertakings, and you can to international law. Now, on 11 June 14, after these orders were issued by the International Court, two police officers called at the home of a law student and intern in my office in Canberra, I mean in Cambridge, of course. They told her that she needed to keep her nose clean if she wanted to end up a lawyer. And they took her to a police station and subjected her to a long period of interrogation after the court orders. She quite appropriately refused to sign a statement they'd prepared, but she did reveal, fortunately, because these sort of cases are compartmentalised, not have known the full significance of it. I asked her if she knew who Kay was. She said quite honestly and correctly that it was password protected and staff didn't know. She then revealed that she'd been my note taker at meetings with Shanana Guzmao. She'd been my note taker on occasions in Oslo, in Norway, where I'd been investigating how billions of dollars of helium had been given away free by Alexander Downer to ConocoPhillips and free as a defence listed critical commodity. Australia's been searching for its own sources of helium since the 1930s. Airship days, what's called a critical commodity. The younger ones now know that the critical commodities are now in our mobile phones and rare earths and so on. Helium's one of those, still is. The real thing about the Timor Sea is that it's a vast granite dome. Helium, which leaks from uranium and other isotopic elements, floats up into granite domes, is caught there for all time. Around the rest of the globe, the helium seeps harmlessly off into space. But sources of helium didn't exist in proper volume in Australia and nowhere in the Southern Hemisphere. It's a fantastically needed commodity given away at night in an office in Parliament House to two companies. Timorese were cheated of it. It's the definition of petroleum, which is universal, was altered, and 14 Timorese signed a deal that excluded the helium, which was given away. And of course, the Australian Defence Department didn't know that was happening. So I've been calling for some time that matter to go to the ICAC. I know at least one person in this room is vitally interested because there were compulsory acquisitions and takeovers and other skullduggery associated with multi-billion-dollar scandal that must go to the ICAC. Now, that young clerk of mine not have been completely across those matters, but the Australian government then found out Timor was onto the helium. That was a critical discovery components of that. So nothing is safe. Nothing was safe from that bunch who were in power. Now, it got worse. Witness K was detained by the police, warrant issued by the Chief Magistrate, the same one who J, and ordered to be taken under obscure crime provision, police premises, by the passwords for his computer. That total an absolute breach, firstly of his legal profession. I'm his lawyer. Not been charged with anything. Total breach of the orders of the. How that magistrate came to issue that has to be the subject of the investigation. Where do we go from here? How may we know whether matters such treachery, such dishonesty, and that perhaps the intelligence community wishes to reveal is unable to have dealt with echelons? Where may they go? Well, the answer is you'll end up like Witness J. Okay. Nowhere to go. This country at the moment. The title of my lecture address is a bit misleading. The title was The Challenge of Representing Them. You'll get arrested if you're treated the same way as I am. I'll tell you why. Shortly after the then attorney had issued the warrant against me, young Christian introduced two bills in the Parliament. First one was called, as it would be, the National Security Legislation Amendment, Espionage and Foreign Interference Bill, and then the Foreign Influence and Transparency Scheme Bill, which we know more about. The first bill introduced new spying offences. It was time to amend the Commonwealth Criminal Code, and for the lawyers present, sections 122.4, capital A, 1 and 2 deal with the communication of secret information and the receipt of that information. Now, the way lawyers work is that, as Kay did, they ring and speak to a receptionist usually and seek an appointment. And they say what it's about. Some clients are keen. They drop off an email with the facts. They drop off a letter. They summarise things. I mean, clients these days do Google and know what more about the law than we want to, but that's the thing. And now, this new law makes it an offence for an innocent lawyer to receive protected information. That is, to receive the title request for appointment. The appointment might be, I wish to have an appointment, deal with the promotion system within ASIO and an unfair promotion. That's an offence. Recipient, regardless of whether the recipient invited that piece of information, the recipient has committed an offence. It's an extraordinary provision. And of course, it goes further to nominate who the protected persons are. In Canberra, there are about 22,000 protected persons, that is, members of the intelligence community. Most of them do, the vast majority of them do a great job are ethical, dedicated, good people. Now, that law stands, and you commit an offence if you receive it, you collect it, you possess it, you made a record of it, you copy it, you alter it, you conceal it, you communicate it, you publish it, you make it available, even to a barrister. It's an Orwellian provision. Got through the opposition. 2018. There's so much work to do for the new federal government. National security in that legislation that Christian Porter introduced is so broadly based that it could include the reference to misconduct and unlawful conduct. Nothing to do with national security as you would broadly think it. It criminalises disclosures that are in the public interest. Public interest is defined down, and they were shrewd. They gave an exception for a person engaged in the business of reporting news, presenting current affairs, or expressing editorial or other content. And at the same time that person reasonably believed that engaging in that conduct was in the public interest. We'll tell that to Annika Smethurst, because she was one of the first persons to be pursued under that new law, right? Now, so they fell over themselves to say, oh, we'll look after journalists. But what about a blogger? What about Julian Assange? What about a separate news site? The defence refers to persons of the media, but media is not defined. And who's engaged in the business of reporting news? Does that include Crikey, for instance? Just the mainstream press, because the Murdoch press got offside, so on and so forth. So now, the position's bleak. We all hope that there'll be some considerable work done on these issues. Just want to end with a couple of points. The very great challenge for us all is not to get wedged and seen to be weak on terrorism and to listen to this flat trap about national security that's out every time something decent required. During one of these secret hearings, got to know how the court system works for the secret hearings under this law. Judge has to adjourn matters, and workmen come in matters. They tape up the C2C cameras in NU 20 Canberra, tape that up. Court transcription service is ejected, and a person from intelligence service comes in with his order. No amplification in the courtroom. It's very hard to hear, and secret hearing. Secret hearing, most of the time, about what we all know. The whole world knows, but it's secret. Neither confirm nor deny. The Holy Grail in Canberra is you neither confirm nor deny that which you know, that I know, that I can't speak of, but you can. Such a farce. 60 court appearances, 4 years of it, while these sleazy toadies wanted to do, can't talk about, Dilly, try and hide their activities. You see, the coalition's gone. Alexander Downer's now in England getting a fee for helping immigration policy or whatever he's up to. But bureaucrats are largely still in place. Those of you who read the Australian Book Review, as I do, will see that James Curran said this just a few days ago. It's very, very interesting. James said that most of the staff, this is Professor James Curran, the key advisors who shaped the response to China under Scott Morris have been left in place by the Albanese. This means the harder thinking about the connection between economic and national security is not being done at the highest levels. Incredibly, in a secret hearing the other day, an expert trotted out, subject I can't address, that was one of the people in 201, 204 were involved somewhere. That was just mind-boggling. The court's closed and in trots an expert. Now, there was one afternoon when the full group of heads of intelligence agencies and this very challenged man, his name's Zulo, it won't be, a lot of you won't be familiar with, but he was Dutton's head of department. They all gave evidence, and they were led in to give evidence. And we had our group of witnesses, Gareth Evans, who I've met up with after years of jousting for East Timor. Gareth was there, the former head of the defence staff, Admiral Barry, Chris Barry, John McCarthy, our former ambassador in Washington, and Carter, and others who came to give evidence for me. But when these heads of agencies came in, I just remembered, given my great age, I remembered seeing the films of Stalin's purges, 36 and 7, when Stalin pushed general after general to give evidence against their own colleagues during the great killings, 36, 37, that decapitated the Russian army. And you could see they didn't want to give evidence. They prodded forward. Look, just like that, Canberra Court. And you've got to remember this, that very early in the piece, Director General of ASIO, Lewis, said he saw no reason why he security, and he said that, at least his letter. Here were agencies, and I want to make clear here tonight, even though ASIO officers raided my chambers, they didn't know at that time the background to no difficulty with ASIO here. And it was sad to see the way Porter had the government lawyers pushing people forward uncomfortably to give evidence against me. And I could say more about that, but I should be more discreet. But my recollection of intelligence matters and issues is such that I'm reasonably informed. I've been very concerned, along with others, with the fact that the collection of intelligence has been taken over and overshadowed by grey cardigan bureaucrats, not specialists. And that's a massive problem in our country at the moment. It was exemplified during 1999, 2000, when Downer and his minions, his bureaucratic minions, hid the clear intelligence information about the impending military-inspired militia violence. Late Des Ball has written about that. Anne over here recalls it at the time. It was so scandalous. We knew the violence was coming. Downer dissimulated, the Prime Minister dissimulated at the time, but there was a massive leak of secret intelligence material. And that blew them out of the ground. It deeply angered the Americans. And of course, as you now know, Bill Clinton said, if you don't get a peacekeeping operation in, I want transit rights for 15 years. Don't even think that Interfet was a beautiful, great, lovely idea dreamt up in Canberra because we love the Timorese. No way. It was something done properly at the end, but only because they were found out. Now, the problem is this. If we keep giving political control over our intelligence services, more leaks, lower morale, it's not good for our services. And what was not good, that one of our great lessons from the Cold War was that you keep the agencies compartmentalised. As you now know, Philby went seamlessly from MI5 to MI6 to all through the agencies. And the British intelligence was utterly compromised in the later years of the war and for 15, 16 years after that. It was just unbelievable that Prime Minister Turnbull and Dutton created a mates pyramid and has created this thing called the Office of National Intelligence. All the mates, that is, the guys who came and gave evidence against me, they're that. What I'm saying to you tonight is that it was clear 15, 20 years ago when Leighton Constructions was saying we can build the atoll sea rising level defences in the islands. We can do that, just give us an aid budget. We've built marinas all around the northern tidal reaches of Australia. We can do that work in the Pacific. Did we fund it? Prime Minister Howard's principal advisor in the Pacific in those years was a bloke called Nick Warner. He's just retired as head of the National. China moved in because we left the space for them. Inexplicably, we leased the port of Darwin. Inexplicably, under the Howard Downer government, China was accommodated. And why? I represented two defectors from China, two very courageous defectors in 2004-05. They were brought in by my clients, the Falun Gong, and they were insistent that the information be passed to Allied services, not Australia, because it was unsafe, and they were flown quickly to the United States. And a much bigger budget was given to ASIO after that. It was an astounding experience to deal with those defectors. And I'm very, very concerned about the current structure of our intelligence services. I think, Michael, I should say that anyone who's got further interest in this matter should read Michael Kirby's very interesting article in the Australian Law Journal. It's volume 95, and where he was unable to openly assist me, but he did an article on the problems with our intelligence services. It's unprecedented, but you should read it. He points out that not since the Hope Royal Commission has there been an independent review of our agencies. It's always been done by bureaucrats, other bureaucrats. I think if you're interested in my call for a Royal Commission, which it must be, we need an early Royal Commission into our intelligence services. And we need decent laws to allow public interest disclosures by members of the intelligence services where they can safely disclose matters that should be disclosed in the public. And it was too tortuous of me to use the Permanent Court of Arbitration, even though it was secure, confidential. It gave rise to a suggestion that foreign powers were finding out information. It'd be far better if we could have a sophisticated system to allow members of the intelligence community who need to make a public disclosure properly treated. Michael, I think that's all I say, and thank you. Yeah.
Very much, Bernard. Bernard is happy to take some questions, subject to the caveat that he mentioned about all the things that us know about that he's not allowed to talk about. So, some questions. Jean?
Sorry, every second, so you second, so what was your position as second?
I was first secretary in Paris.
First secretary.
I didn't work in the embassy.
Yeah, are they always speaks though? I mean,
What?
well, I spent a bit of time with company. Everyone knew that.
Well, in the Soviet embassy, it used to be the chauffeur.
Is that a thing?
Oh, no.
You weren't
There are overt and covert members of the intelligence associated with embassies. Overt are people who are declared to the other side. They work with the Chinese intelligence service because we have shared interests, even with the Chinese at times, right? And then there are covert members of the intelligence service, and they never go near an embassy. They're not working in embassies. I can safely tell you that in the 1930s, it was Cook's Tours, British, right? You work for Cook's Tours, right? So that was revealed by the Soviets, but I can't go further on that. Sorry. We have a rule in law that if you subpoena material, you can't use it publicly, right? We subpoenaed Woodside because we wanted to know the fees that have been paid to Woodside's consultants. Well, corruption, so far as public office is concerned, has many guises than that. And it can be, I see Plunkett nodding, it can come a long time after you leave politics. It can come as a directorship with quite a substantial yearly fee. It can come as a straight consulting fee. I know your answer, but I'm not able to. Now, that's about consulting fees. You want to ask me about the helium? Well, the helium, Robert Cato there knows all about it. He gets an honourable mention in my book. The helium has been worth billions of dollars. Why was it given away? We need ICAC to tell it. Need that. I'm not going to telegraph the punches. They're coming.
Bearing in mind that national security and
Director General of Intelligence and Security, known as IGIS, is a joke. That person works under the Prime Minister's Department. Do I say more? I mean, I've got detailed papers on this. No powers at all. IGIS will pretty well deal successfully with the spook who takes bugs home to check on his wife or his mistress, I'm sure. But when you want to talk about an affair of state, that would involve the sort of issues that I'm talking about tonight. Forget about Aegis. Margaret Stone, the late Margaret Stone from here, of course, became Aegis, and there's a very revealing correspondence between Senator Rex Patrick, Senator McKim, Andrew Wilkie, others, perhaps Graham Perrott from up your way here, where she says, no, I'm not going to investigate Collaery's allegations. Kay was referred by Aegis to me. He wanted me. He was approved by the Inspector General of Intelligence Security to seek advice. How would I have known where witness K had served? How incompetent, how stupid to send someone like K to Chinana Guzman's legal advisor. Think about it. Think about it. It wasn't entrapment. That never entered my head because it wasn't entrapment. Fancy doing to a barrister that kind of ethical challenge. What was the Inspector General, who lives over here at Noosa now, what was Ian Carnell thinking of? Prove Kay to see me. How would I have known where Kay had worked? Right? They're the ultimate ethical binds that we in the law can get into. Now, was I to stay quiet? Yeah, what would I be doing up in Dili? What would I be? How comfortably might I have been sitting in a certain room giving advice? They are massive challenges for my profession, and the Aegis disgracefully failed to protect me as well. Get about Aegis. It's more dangerous to have Aegis because it implies to the members of the community that there's some inspectorate going on. There isn't. Bless Margaret Stone. I mean, she tried her best, but she shouldn't have taken this.
How much of this do you see being investigated by?
Yes.
Yeah.
Fronting. Yes.
Okay, next question. Okay.
Just sort of the general one, you sort of seem to make a bit of some legs a couple of times in your talk to say that, you know, ASIO people are all rated you were under instructions, etc. Given all that you know, feel that the public can have general confidence in ASIO and how it operates and intelligence service more broadly?
Broadly, yes. ASIO has been subjected to so many court cases, so many inquiries. It has made so many mistakes, the Indian doctor here. It has been reviewed and reviewed and reviewed, and it needs to be careful. It's now being tasked with bringing I've been acting for one of those women who's from Raqqa. That best not mentioned, safety reasons. But ASIO have got some difficult jobs on hand. All organisations have problems. The wrong people want to join them at times. They're doing better. There were problems. I'll always remember as a young man being in Queensland a bit during the Vietnam War up in the Gulf and that, and looking through old papers belonging to your Queensland Special Branch. I kept coming across all these arrests during wartime up in Innisfail and that under an omnibus warrant. I'd never heard of an omnibus warrant at law school. And so when I came down to Brisbane, I saw your then attorney, said to your Queensland Attorney General, look, I'm at work. Never heard of an omnibus warrant. What's an omnibus warrant to pick up Italian cane cutters? He said, mate, simple, the bus. Well, they're the grim days of ASIO and special branch, right? But a lot of people are scarred by early ASIO, and as I am too, but it's ACIS that has no proper role. That's the body. It's close to providing foreign policy advice, needs to be safe, secure, decent, and all the rest.
I had a nice legal question about.
Plenty of lawyers here.
The expression that jumps into my head, speaking.
Yep. Yes. Yep.
Have challenges of that nature?
We tried Chapter 3. Chapter 3 is the provision in relation to the judiciary that means it can't be asked to do executive work. It transgresses the boundaries. If you give a court a chapter, so yes, and so just to explain your question, yes, we ran some Chapter 3 arguments. In my matter, yes, we didn't get far. So what this pernicious legislation does, it orders the judge to give the greatest weight to the opinion of the Attorney General. So the Attorney General in my case gave a note to the judge saying you've got to give the greatest weight to protecting national security. And protecting national security treated as neither confirm nor deny. And my argument is this: until we admit what happened in Dili, we'll never be trusted in our region. It's a matter of trust. It's also a matter of being exemplary, but let's be a bit self-serving. We just need to be trusted. And we're never going to be trusted after that. We just won't be trusted. And that's the issue. And when an Attorney General can tell a judge that he has to give the greatest weight to what the attorney says, Christian Porter, that's what irked me right from the very beginning. Right from the very beginning, Christian Porter.
My question was, I was quite surprised to hear that you didn't really lay that much blame at the feet of ASIO. I was wondering, who do you kind of attribute blame to your prosecution? Is it political actors like the Attorney General that prosecuted you, to the Prime Minister, to ACIS? Who do you think was ultimately responsible for this?
Several senior bureaucrats. You could name them, but and there was a definite view that there can't be any more breakouts from the Secret Service. This was to intimidate the service. And that was frankly conceded. And the bigger breakout was from me, because you sign an agreement to observe the secrecy rules when you represent these people. I didn't sign an agreement to hide criminal conduct. That's the thing. They also claim that when you sign one, they also maintained I'd signed a contract of confidentiality. Again, I can't be bound to confidentiality. We don't have misprision of felon anymore in our criminal code. That is hiding a felony, but you can't be bound, in my view, and that's my argument. Don't forget, I never got to trial. I have particular issues about the Sarah McNaughton, the then Commonwealth Director of Public Prosecutions. Want an inquiry into her conduct in my When I was attorney, I brought the CPP Act into the ACT after the Guildford Six and all the scandals in Britain. We finally got a direct public prosecution. That federal law was brought in 1983, and there was an absolute cast iron guarantee of independence. Ian Temby, I used to call him Humphrey Bogart, that was Ian, I knew Ian well, and I was a great proponent at the time, and I was active politically in trying to get an independent prosecution service. Those of us who were scarred by police prosecutors wanted that. Sarah stood around and let it all happen to me. Her team meekly left court when ordered to. Just who was in charge of my prosecution? I barely appeared in 60 court appearances. And why did she go ahead when the second most important plank in her protocol guidelines are the public interest? There was no public interest in telling China more about this scandal. There was no public interest in pursuing me. Touch wood, never even had a speeding ticket. How much jail time was I going to get, really? What was the facility in prosecuting me? Would it not mean I will bite back? You know, I'm not a conspiracy theorist, but prosecuting me has done nothing but harm our country, harm our image. And talk to Kylie Tennant about secret trials in Iran. Talk to Aung San Suu Kyi. The only time I've ever been arrested was because of her. That's another story. I got taken off a flight to Rangoon. I was representing her. And there's someone in China at the moment, a journalist, being secretly tried. Big deal that we talk about secret trials, and when we do it here, they did it to me. We've lost our innocence. We've got to get it back somehow. We've got to start with a really blood-curdling ICAC. We've got to clean these people up, and then we've got to deal with the Royal Commission into our intelligence services. It's vitally necessary. Come back to ASIO. The Director General of ASIO not only refused Julie Bishop's request to ban Kay from his passport, but openly wrote to me and said, I see no reason in business of national security for him not to have a. For me, that was an extraordinary gesture by Duncan Lewis. Extraordinary. Amazing. And I think they're ashamed of themselves over what they did at my chambers and that. Canberra's a small place, and I've got the personal view. As you know, Michael Burgess and trying to get at a standard. You know, for years and years and years, the lawyers, particularly on civil liberties and that, we've been invited to give lectures, say, at ADFA, at the Military Academy. Young military trainees, even down to NCO, I've got some rallies, are trained in rules of engagement. Put aside the SAS issues at the moment for this. There's an enormous amount of training on ethics, laws of war and all the rest going on in our military academies. But we're giving too much power to public servants who get no such training. They get some training in ethics and values. It's not enough. They make major decisions, whether we get involved in Kabul and places like that. You know, they say you can't let the military make all the decisions. Well, there has to be a balance within that setup. And as far as East Timor is concerned, when I was at the mass graves, you had the wrong people covering up, wrong people treading all over the intelligence collection agents. They were not allowed to speak up about the impending violence. It's only when Admiral Blair in Hawaii got his own sources of information, we found out that Downer was being disingenuous, misleading, even lying. Read it in my book, that the Americans kicked up and said, we're going in if you don't. Don't pat yourself on the back about Interfed. Interfed were fantastic. I was there for years working and all very good, but we pride ourselves sometimes in the wrong places. Well, both of them came to me first, or came to me along the way. David McBride's with Mark Davis, 6-time Walkley Award-winning journo turned lawyer who did his apprenticeship in my practice. I think David wants to be tried. That's the problem. I keep trying to talk him out of it, but I shouldn't say more. The situation is not good because it's very easy for the opposition to wedge Labor on being soft on security and all this. And it's a very difficult road. When I was Attorney General, the police shot a drug dealer. And I remember getting flack over one full investigation into the shooting. So much flack about soft on. It's a cruel game. I helped do the GoFundMe with another young lawyer who was working with me for oil in Adelaide. Amount of the whole set of charges. It's bedeviled by the fact that we all want our tax affairs kept secret. And public relations exercise in that case. And I really wish them well, but they you should never want a trial. No. Juries, people who many times, mostly the jury gets it right. Sure, it's risky, it's risk-taking, and it doesn't help our country. It's bad press for us in our region. And we're developing habits that are in compact with China, I find. Secret trials, Jay being jailed secretly. They're not good looks.
We have actually won't burn it to dinner, so. I think it's there. Yes, you also have a point right there.
Right.
Yeah, it's shocking. Yeah. Never anticipated. I must say, I do remember the national security legislation, and I think we all tend to think, although we wrote some stuff opposing it, that it was a souped up version of public interest privilege, which did not, as you have found out, to your cost. Anyway, thank you, Bernard, for a very interesting and concerning book, but also I think, our point of view, like all of these things with these anti-terror laws, the thing I want to mention is that they are seeping into all sorts of other places, so that now have secret evidence in all sorts of other areas of law justice. We now have people being detained in prison once their sentence is finished, and we've just seen the High Court lazily say that people who have been convicted of good reason have been detained on the basis of some strange piece of psychiatric evidence. And all that comes out of these laws. So once you do something in one area of the law, as civil libertarians said back 2001 and 2002. Doesn't stay there, it to other places because once you do it there, people say we do it there like that. So, which is why we struggle against novel ideas. Perhaps once it's a good idea, not because they're going to do somewhere else. Anyway, Belinda, thank you very much. Illuminating talk. The next Civil Liberties event will be our annual general meeting, which is a really exciting meeting. Apart from that, thank you very much for coming along. I hope you enjoyed the issuing as much as I did. And I thank you for your support, and I hope we can see you here again with our next events next year. Thank you very much.